It's 2:30 and we've also formed a quorum. I now call to order the meeting of the Bills Committee on Stamp Duty Amendment Bill 2013. I'll also invite the government representatives to come in. In accordance with the advice from the legal advisor, I'd like to declare that I possess properties. I'm an accountant. I serve for all types of clients in terms of tax advice, including the Stamp Duty Amendment Bill 2013, but I do not get engaged in the work. Mr. Andrew Leung, declaration of interest. Mr. Wong Ting Kwong, I declare the interest that I had declared before. Mr. James To, I declare the interest that I previously declared. Kenneth, I also declare again the interest I previously declared. Well, this is a reminder from the Secretariat, so as Chairman, I have to act in accordance with that piece of advice. All right, the government representatives have entered the conference room. At the last meeting, members agreed to proceed with clause-by-clause scrutiny, and we stopped at Clause 9 in relation to 29AG. That is page C698 of the Blue Bill of the Chinese version. Earlier, we received from Mr. James To certain requests for the administration to address certain issues. Due to urgency, the letter has already been distributed to you. Well, the letter has already been tabled. So I'll invite the administration to respond to matters raised at the meeting of the LegCo in the past week in relation to Stamp Duty Amendment Bill 2013. Whether or not there are technical considerations or political considerations. I wonder whether the administration has got a response now. If not, I'd like to invite them to consider in detail members' concerns. Such concerns may also be applicable to the Stamp Duty Amendment Bill 2013. Perhaps we should listen to Mr. James To and other members first before we continue with clause-by-clause scrutiny. Madam Chairman, I understand that we're on clause-by-clause scrutiny. But in view of views expressed at previous meetings, as well as views expressed in the LegCo at other meetings last week, if the administration is unable to respond now, I'd really want to have some responses at the next meeting. You see, we're on clause-by-clause scrutiny. If only at the end that we're told that a lot of clauses and provisions have to be amended, then it would be very problematic. So even if they're not going to give us a response today, I hope that next meeting they should give us a response. Because of the budget, I think they're not going to come up with a reply very soon. But at least in the next 2 to 3 weeks, they should give us a reply. Professor Anthony Cheung is from just one bureau, but we have only one government. So the whole administration should respond. I must admit that earlier, at least I myself have placed a great deal of time on the 2012 bill, and meetings clashed. And then we hastily rushed to clause-by-clause scrutiny for this bill. Yet there are actually concepts also applicable to the 2012 bill, but I did not have time to raise them. I did not have time to prepare papers. We shouldn't round up so soon. It's just like the issue on charitable institutions. Nobody have ever asked any questions about that. I think as soon as possible, the administration should be alerted that these are not all the concerns that we have. So they should go back and think about this. Otherwise, they will go back and say, oh, this is clause-by-clause scrutiny already. Very soon, the scrutiny work will be completed. Don't be so naive. Many issues have not been discussed yet, so take this opportunity to think through all these issues thoroughly. I believe at least there are technical issues to be ironed out. I don't think the administration will have that thought. In the past few days, we focused our attention on our debate, and during the weekend, I also went through these issues. So for the administration, for part of the views expressed on the 2012 bill, politically, technically, and legally, there may be considerations about this particular bill. Whether or not they are applicable to this bill, you should think about them. Anyway, we're just shortly after the enactment of the 2012 bill. I'll listen to the administration's response first before mapping out the next step. Mabel? Thank you, Chairman. Thank you, Mr. To. I think we'd all like to facilitate the scrutiny of this bill. In his paper today, Mr. James To sets forth 6 points. Apart from these 6 points, in accordance with the progress of the scrutiny of the 2012 bill, we've been closely monitoring CSAs proposed by the administration and members. And last time when we started clause-by-clause scrutiny for this bill, on the basis of our knowledge and understanding, and in accordance with the explanation offered for the 2012 bill in relation to the CSAs, in this particular paper, we've offered a preliminary response. For example, where there will be consequential amendments and where policies and scenarios are not really consistent, we may have to have other considerations. So in today's reply paper, we've set out all these considerations. I noted that Mr. James To and the chairman mentioned the 2012 bill, which was just enacted. We hope that as soon as possible, on the basis of the enacted version of the 2012 bill, we'll work on the marked up version of the bill. We'll talk to your legal advisor where we may move consequential amendments or where there are repeated or duplicated provisions. Together with your legal advisor, we'll work out another paper in response. That will be a more comprehensive approach in response to members' concerns. I think we can continue with our clause-by-clause scrutiny. We'll, of course, not consider very soon we'll complete clause-by-clause scrutiny. We would like to have ample discussion here. There may be points not raised in Mr. James To's paper today. Do submit all your concerns to us and we'll reply in black and white as soon as possible. All right, so we'll continue with clause-by-clause scrutiny. The administration understands very well members' concerns about various provisions and arrangements in the 2012 bill. So I hope that the administration will review the technical and political implications of the 2013 bill and report to this committee as soon as possible. Mr. Sin Chung Kai, are we going to discuss paper 943? In accordance with our decision last time, we'll continue with clause-by-clause scrutiny first. As for the contents in the paper, when appropriate, we'll go through them. Anyway, the administration is to review all the concerns. So, please rest assured that concerns raised for the 2012 bill can be discussed here if members so wish. And then if we can have a second reading resumption debate for this particular bill, members can also speak up. Mr. Sheck, you have something to say? Sorry, the speaker is not coming through. Mr. Sheck was not coming through. Well, Madam Chairman, you enjoy a high status. Oh no, the platform is higher. I have to declare that I represent the land development and estate agency sectors, and I possess properties. Mr. James Toh, you have something to say? No, I'd like to say something about the provisions. So let the administration speak first. Well, as I said, last time we stopped at clause 9, that is Blue Bill page C698 on 29AG section. So if members are ready, I'll ask the administration to introduce the contents of 29AG first before inviting members to ask questions. Madam Chairman, I recall that last time we stopped at clause 9 in relation to section 29AG. We explained something about the immovable property, dates of acquisition and disposal. If more than one agreement for sale involves the same immovable property, what should happen? We actually completed that section, so we should move on to 29AH in relation to mentally incapacitated persons and minors. I believe Mr. Toh will be interested in this, so we're ready. So please continue. Mentally incapacitated persons is marked up version page 21. Oh, sorry, I haven't got 21. I haven't got page 21. Madam Chairman, for mentally incapacitated persons, is the definition the same as that in the 2012 bill? That is, the trustee can put forth a self-claim. That is, he can claim that he is the trustee in the deed. Is that correct? In my opinion, we should confine this to some statutory procedures. For example, those under the guardianship law or laws on the mentally incapacitated persons or court orders. So I wonder what the administration is thinking about. During the debate, the answer was in the negative, because the Inland Revenue Department will also ask questions. And during the debate, I asked, the trustee will say, I have no more instruments. This deed is the only document, the only instrument, and I'm the trustee. Can I have a more specific reply now? Because during the debate, another bureau director, Professor Cheung, did not say yes or no. Well, the Deputy Secretary has not explained this yet. Is the definition for mentally incapacitated persons the same as that in the 2012 bill? Well, 29AH involves the minors or instruments involving minors or mentally incapacitated persons. Roughly speaking, the content of this provision follows the provisions for BSD and SSD in relation to minors or mentally incapacitated persons in relation to trustees or guardians, and an exemption will be offered. So this is to follow the practice of the previous bill. As for the definition of mentally incapacitated persons, we follow the definition in Cap 136. That is, for those who have contracted mental disorder or are mentally handicapped. And in executing this exemption, the IRD will require the trustee or guardian to provide evidential instruments such as custodian orders or deeds. As for minors and their guardians, for instruments that are satisfactory for transactions in conveyancing, they will be accepted. In fact, this point is already mentioned in paper 943. In the Bills Committee, some members were worried that if we allow a trustee or guardian of a minor to be exempted, there may be abuse. So in the 2012 bill debate, we withdrew the exemption. Therefore, to a certain extent, we've already dealt with the abuse concern. And in this 2013 bill, we basically target those who possess a number of properties and have to pay multifold stamp duties. So given the trend of BSD and SSD, we're going to provide the same exemption to minors or mentally incapacitated persons. We believe that only by doing so, for Hong Kong PR children who are minors, when they purchase properties, apart from paying BSD, there's no policy to require them to pay the so-called DSD. Otherwise, the strength of the DSD will be multiplied, and that's not the policy intent. So that's what I'd like to explain to this Bills Committee. All right, so this is very clear.
Madam Chair, she's not answered me the question. My question was, if there's no order appointing a person as the guardian, can he just point to the deed and say that, well, I am the guardian and this is the deed? And given that, do you not extend exemption? Well, according to the ordinance, for the mentally incapacitated person's definition, the IRD will follow the definition in the relevant mental related ordinance. They will look at written submissions, documentations to extend or not extend the exemption. And we believe that this will not adversely affect the rights of mentally incapacitated persons. And we also do not unduly add to their burden when making such applications. Madam Chair, please ask her to answer the question. Now, the so-called written document is basically one and the same, and that is the deed itself and nothing else. Is that right? Perhaps we will wait for the next round in order to allow time for everybody. If I can just suggest 4 minutes for each member. Mr. Shek. Well, Madam Chair, I'm so happy that things are put right. I'm so happy today to see that government officers are abiding by the basic law and acting according to justice. And I think for Professor K.K. Chan and for Smable Law in being in the 2012 ordinance and its interpretation, I am so happy that there is this very clear and just stance adopted by the government. Yes, Mr. James To. I would want to go back to the question that I asked concerning the trustee for the mentally incapacitated person, whether he be a Hong Kong permanent resident or not. If he points to the deed and nothing else, no court order, nothing, would you find this insufficient? Well, actually, for the actual implementation, I'll ask the IRD to answer that question. Yes, please. How would you actually handle this if this kind of case should arise? Mr. Pham? Mr. Lam? Well, at present, there is no clear stipulation as to how a person can evidence himself to be the trustee. And usually, we would handle these cases according to how we usually handle other cases. And that is apart from the transfer document, wherein there is a trustee named, we would also ask for a declaration for trusteeship. And if that is lacking, then we will ask for other documents. If he can provide other evidence to persuade us and to convince us that he is the trustee, then that would be acceptable. Well, if he cannot do so, will this exemption not be extended to him? You just said that you will ask whether there is a trustee declaration, or trust declaration, is that right? Well, that is, at least the trustee should have that declaration, but if it is indeed not available or lacking, then we will ask for other evidence and information. If we find that the case is not strong enough to sustain the exemption, that is, if we are not convinced, we will not extend the exemption. Well, the question is, if there is a trust declaration, but there is no court order, no guardian evidence for that suspected mentally incapacitated persons, would you or would you not extend the exemption? Madam Chair, as I have mentioned just now, because the ordinance is silent as to what constitutes a guardian or trustee, then we cannot say very clearly that the person will have to come up with whatever document or evidence to evidence his status as a trustee. Well, that is a very good answer. That is good. Now, for the amendment that I've proposed for the 2012 ordinance, would you accept it or not accept it, and if so, on what grounds? Well, thank you very much for Mr. James To's question. For minors or mentally incapacitated persons, we do see that because they have that need, and in our stamp duty new amendments, we do not want to add to their burden, and therefore we continue to use the existing definition for mental incapacitated persons and also follow the existing mechanism in extending the exemption. So as apart from BSD, for DSD, we will not be slapping on them even more stringent requirement. Madam Chair, this is not slapping on more stringent requirement. This DSD, according to another secretary, his understanding is completely different. He said that the exemption or such evidence is not necessary. And this is, as your colleague at the IRD had mentioned, the situation is that there may not be certain trust documents or court orders to evidence that status. And if what exactly will you be looking for to evidence or prove that relationship? Now, you're wasting a lot of time. A lot of time had been wasted on this roundabout discussion. Can you please give us a submission on an explanation? This is not about whether you prefer red or blue. This is not exactly addressing my question to the point. Yes, this is a question raised by Mr. James To on the 2012 ordinance. Can you please respond to that? Well, for the 2013 ordinance concerning mentally incapacitated persons, we do have a definition, and also in the exemption clause, we also allow the IRD to, according to their satisfaction of trustee or guardianship, extend the exemption. But for DSD, because we are really focused on persons who hold or own more than one property, we do not want to extend more stringent requirements on persons who do not have the ability to prepare more or provide more documents, etc., where these persons, that is minors or the mentally incapacitated persons, are indeed the owners of such property. Yes, if we can be more clear, it has been submitted by Mr. James To that in implementation it will be more clear for all concerned. I can understand that point, but on the other hand, we believe that what is now here is sufficient. We would be happy to discuss this further with Mr. James To. Yes. For persons with mental incapacitation, as Mr. Sheck had pointed out, if there is no major abuse or room for abuse, we would not want to slap on other restrictions or requirements. Now, my question is, for the 2012 and 2013 stamp duty ordinance, have such cases emerged, that is, cases involving the mentally incapacitated persons, the guardian or the trustee purchasing properties, whether it is residential or non-residential? But of course, if there are many of such cases, we have to be very careful. On the other hand, I also note that past history does not indicate occurrence incidents in the future. Yes, I see that Mr. James To's import is really to make this more watertight. But for trustee declaration, where it is valid, would it follow the existing mechanism? And that is, there need not be any court order or any judicial procedures. Well, we will provide figures on the number of cases, but for the transactions going through the IRD for trustee or guardian-related cases, they are few and far between. And for minors, cases involving minors, there are less than 30 of such cases. As for incapacitated persons, these are even fewer in number. Well, it's been over a year since its promulgation. I would like you to go back and look at the exact numbers. And I'm sure there is a guideline during the implementation. Well, basically the members are worried, or myself, I'm worried about abuse in the process of implementation. If you can provide more information on that point. And if the minors related cases come to you, how do you minimize such room for abuse? Well, I hope you understand where we're coming from. All right. We will continue. Yes, is there another question from Mr. James To? Yes, indeed. I'd like to ask our legal advisor or the government officers. Well, let us talk about minors. The mentally incapacitated person seem a mouthful, but let's just talk about minors first. Is it applicable to two scenarios? My question is it only in exchange of property that this will become applicable? Well, actually, first-time purchase as well. So, of course, for first-time purchase, there will not be the DST. That is clear. But on the other hand, is it true that for minors, whether they are from non-Hong Kong resident parents or not, but of course, those with non-Hong Kong resident parents will become a majority in our consideration? You have mentioned that this actually adds to the costs. Let's say, hypothetically, if there's an adult who purchases a flat and he uses this loophole, wouldn't that be equivalent to the situation where he's buying the same flat because the exemption is extended to an insider? In this double stamp duty arrangement, why do you say that there is less room for abuse? I do not understand. I'm sure Mr. Sheck will be opposing this because he would feel that minors have the right to purchase properties, and we can go to that point later on. But why is there abuse in one case and no abuse in another? Madam Chair, is there a document which explains why the Bills Committee asked questions as to why this had not been taken out? Taken out what? Taken out adults. Well, perhaps Ms. Mabel Chan can explain. Yes, I think your explanation will be very clear. I hope that there will be a written submission.
In fact, this is in the new paper. Anyway, we can have an integrated discussion. Well, you haven't missed this. This is the first time we discussed 29AH. As for the latest paper we submitted to this committee, that is paper 943, we spell out certain details to specifically explain our position. For the 2012 bill, in relation to the trustee and guardian of minors, the exemption had been withdrawn, so we'll make consequential amendments here. And this is specifically explained in Annex 1 to the paper, Item 3. Perhaps I should briefly clarify that just now I did not say that under the 2013 bill there would be less abuse. I did not say so. It's just that we understand that previously members mentioned that at the moment, through the trustees and guardians of minors, there might be abuses. The Bills Committee did query whether or not such trustees and guardians and minors have a home ownership need. But there's a possibility of abuse. Through the 2012 bill, as the exemption was withdrawn, these minor Hong Kong PRs, when they purchase properties through their trustees or guardians, the instruments have to be stamped. Therefore, the worry about abuse will attract a certain degree of punitive effect. So we don't really need another withdrawal here. As for DSD, the policy intent was to provide a DSD provision. So we have to look at the minor itself, whether or not he has actual interest in other properties. And this can be checked with the land registry. That is, who's the actual beneficiary of the property. So whether or not it is the trustee or guardian signing the instrument, it doesn't matter. If the minor is the actual beneficiary of the property, the instrument will have to pay DSD because another property has already been purchased. Mr. Abraham Sheikh, Madam Chairman, the Democratic Party and Mr. James Toh said something about the 2012 bill and the 2013 bill. They're two different bills. Well, they supported something, but that doesn't mean that that something is correct. So if we put that something back into this bill, it is even more incorrect. Well, under the 2012 bill, if you buy a property, you have already paid. Why they should pay again under the 2013 bill? Well, last time they supported Mrs. Regina Ip, an EXCO member. The CE said that he would not accept any decrease of harsh measures, but he can accept increased harsh measures. That's already not in order. Why is it that not even the degree of harshness has been determined? He has determined to accept an increase in harsh measures, but then the Democratic Party supported that. when the administration introduced the 2012 bill to us, we're talking about minors with non-local parents. We're not talking about minor HKPRs. Again, this is also a kind of taxation law. And we're talking about increases in harsh measures. There are different bureaus. Some bureaus are competent and able, some are not. Some bureaus are barbarians and they try to distort the truth and come out with some crooked arguments. Well, one wrong plus one wrong does not mean that you become right. It's just that you make an even bigger mistake. Well, just now the Deputy Secretary said that the spirit is not to increase the harsh measures, but to look at the basic rights of these people. These people have already been punished once. Why should they be punished again? So that's the policy intent. Mr. Wong Ting Kwong speaking for the first time. I'd like to ask the Deputy Secretary a question. For the BSD and DSD passed under the 2012 bill, they target non-HKPRs. When these people own properties, will adopt certain policies. As for this 2013 bill, the DSD proposed targets another issue, that is first-time home ownership or first-time property purchase. So there are two different policies, two different pieces of legislation to target two different issues. So for DSD under 2013 bill, the exemption is targeted as first-time purchase, not minors, not people under 18 years old. Am I correct? Is my understanding correct? Well, for residential properties, you can understand the issue. So, Deputy Secretary, thank you, Madam Chairman. Thank you, Mr. Wong Ting Kwong. Let me reiterate that the two bills are to attain two different policy intents. For the 2012 bill, for BSD and SSD, they target non-HKPRs in relation to the stamp duty to be paid for residential properties. More tax has to be paid. As for this 2013 bill, the policy intent is to target another group of people for immovable properties, residential or non-residential. The stamp duty will be doubled. And we're not talking about the actual beneficiaries with no other properties. That means if a person has no other property and he is now buying his first property, we'll give him an exemption such that he will not have to pay double stamp duty. I'd like to take this opportunity to explain another point. Mr. Abraham Sheikh used another angle to explain the government's position. But let me reiterate that there's only one government. Different bureaus join hands to do one thing. It's just that for different policies, under different circumstances, we independently examine arrangements and exemptions to see whether or not they are appropriate. I have to make this point very clear to members. Well, let me say that for the DSD under 2013, for the mentally incapacitated persons and persons under the age of 18 and who are HKPRs, their guardians or trustees or whatnot, if they possess one or more properties already, they will be governed by the DSD under 2013 bill, right? Well, for mentally incapacitated persons, if they hold one or more properties already, if they're the actual beneficiaries, they will be subject to this double stamp duty under the 2013 bill. Mr. James So, are you on the same issue? Well, I have a question for either the legal advisor or the officials. Are there two scenarios here? If a minor if previously he is a minor and has got a trustee, then when he buys another property and he is still a minor, then this minor possesses two properties, so he has to pay DST. Yes. So there's only one scenario. When a person buys a property and uses a minor as the beneficiary, and then another adult who has already possessed a property, he can still be exempted from DST because the actual beneficiary is a minor. So this will only be applicable to that scenario. Yes. What about change of property? Well, if I heard the Deputy Secretary correctly, she is saying that because of the 2012 bill, if a person buys a property by using a minor, then he has no exemption. He has already paid 15%. Oh, maybe I should say exchange of property or change of property. Then the second property bought will have to pay stamp duty, but not double stamp duty. That is, 50% is all right. If there's an increase of 4 or 5%, then it's not too much less. So that is your rationale. Deputy Secretary, well, let me see whether I've understood Mr. James To. As he said, if a minor purchases a property through his trustee or guardian, he has to pay the 15% stamp duty. And the policy intent of this 2013 bill is to target those people who, in the register of the Lands Registry, already possesses a property. And today, whether or not that person is acting on his behalf, if he already possesses a property, he will have to pay 4 to 5% more stamp duty. But here, if he is not acting for himself, if he is acting on behalf of a minor, then there's no intention for us to charge him an extra 4 to 5%. When designing this DST regime under the 2013 bill, we want to target those who hold more than one property. If the minor does not hold a property and he appoints an appointee, guardian or parents to buy a property, then we won't, just because he's doing this through a trustee or a guardian, charge him another 4 to 5%. The decisive factor is whether or not he is the actual beneficiary of another property already. In other words, whether it is 15% or 20%, the effect is relatively marginal, so you don't think you need to take it out from the bill. Deputy Secretary, in the deliberation of the administration, the main intention is to look at our policy intent. We don't just look at the increased stamp duty is 4% or 5%, whether or not it is effective. I think we have to clearly spell out our policy intent. That is to target whether or not he already owns a property at the moment before we impose the extra stamp duty. Our legal advisor also has something to say. Madam Chairman, for 29AH and the withdrawal of the mention of minor in the 2012 bill are not to offer direct exemption. It's just that when calculating the exemption concerned, the minor or mentally incapacitated persons, how should he be considered? And in the 2012 bill, the concern is whether or not the party in question is a Hong Kong PR. And for the 2012 bill, before it was amended, the person has to satisfy the exemption requirement under the 2012 bill. It's not because of the mention in the provision itself. Originally, it was the trustee or guardian who purchased the property, who have deemed to have purchased the property on behalf of the minor or mentally incapacitated persons. So the exemption was given. But then for this 2013 bill, the decisive factor is whether or not the actual beneficiary already possesses another property. And the government is proposing this calculation method. If the trustee or guardian possesses a property himself, if the government does not give an exemption, then if he buys a property on behalf of the minor or mentally incapacitated persons, the guardian or trustee will have to pay extra stamp duty. But the minor or mentally incapacitated person does not possess a property at the moment. It's just that they're purchasing for the first time through their trustees or guardians.
I totally understand. I mean, if the legal advisor told me what he said, I would have understood, but the government is not saying that. The government is saying that there is a policy intent, and for this particular bill, the intent is that the double stamp duty is itself a very good device for forestalling such activities. But if you open up a big exemption, room for exemption, then it defeats the purpose. Is that right? Well, Mr. Shek, well, my rejoinder to Mr. To is that the policy intent is really whether the person is a previous owner or an existing owner of another property. This is exactly the government's stance, and this is exactly what the LegCo raised some time ago, and that is whether the person is the purchaser is a permanent resident or not, and that was in the 2012 policy intent, which was to allow Hong Kong people to buy Hong Kong property. But it was a cookie cutter in the sense that those under 18 were also affected, in the sense that because the parents were non-permanent residents. And there was fear of criticism of discrimination against the non-Hong Kong permanent residents. But now, for this particular ordinance, it is about the second property or any property other than the further to the first one, and of the beneficiary. Well, I'm in support of you. I think the Secretary, I think the spirit is correct. Why would a minor, anybody under 18, be paying 8.5% if he owns but one property? And the situation or the identity of the trustee of the guardian is another matter. We will have to look into that. I mean, the government will have to trust that Hong Kong people speak the truth, are honest, not to presume that they are liars. Yes, perhaps you can come back. Well, Mr. To, concerning one property, two property, I do not know whether there was a previous meeting. I was not at the meeting. I remember there was a member of the public who described his situation. He bought two small units, 400 square foot each, and he, under legal circumstances, knocked down the wall and joined up the two units And according to the bill, he will only be eligible for, let me put it this way. No, there cannot be refund for him, strictly speaking. And of course, if I refer to the law, I know that that should be the case. But on the other hand, I do not know whether in the government's eye, for certain scenarios, the law may have to be amended to take into account these scenarios, but at the same time avoid any possibility of abuse. Yes, I have also received the letter that you talked about, and we have forwarded it to the government. Have they responded? Well, this is an exchange of flats, because there was a second flat to the, but it's not about minors or mental incapacitated persons. Well, true. Yes, it's not related, but I just don't know where that case should be brought up. No, they haven't come back to us on that. We will be discussing that. Oh, that's fine then. But for the case mentioned just now, there are two properties owned, two properties involved. There are two deeds involved for the two units, but there cannot be any unity of lease. It doesn't work. And there is a division of species. So there are two deeds involved, two units as well. It doesn't mean that where the units are adjoined with a connecting wall knocked down, it doesn't mean that there will be one deed only. Yes, the Secretariat also confirms that the letter had been forwarded to you. You have that on hand. Mr. Wong Ting Kwang, I think the government will have to consider this further. Concerning the two units being joined up, there are also situations, that's one scenario, and also scenarios where there are two deeds involving one, the flat itself, and one for the parking space. This is my own situation as well. I have two properties, so to speak. One, the flat, two, the parking space. This is very real. So when Mr. Shek raised this situation, I think of my own case. Yes, I have two different deeds. But when I bought the property, they were in one lot. But there are two deeds, and will I be looked upon as owning two properties? So the DSE would apply, and there will be no exemption either. Yes, Mr. To. Yes, this is a very real situation, as mentioned by Mr. Wong. And I think the legal advisors will have to look into this. Of course, the government will have to take the lead in studying this scenario, where there is one deed for the residential property plus the parking space, and there is, well, if it is a one-off purchase, flat plus parking space, would you look upon that as one property or two separate properties? And let's say if you look upon it as one property in that scenario, but if the purchase were made separately for the property and the parking space, then I think it would be quite similar to the situation. It should be looked upon as the same property. Yes, and what about the scenario where he already owns a shop property? What about that? And this is the first time he's buying a residential property. How would that be handled? Now, we're talking about the policy intent again. If we're talking about exchange of flats, it is flat plus parking space exchange to another flat plus parking space, not flat to shop. Well, for some people, whether the parking space is in the same deed or not, I mean, there are situations where it is in a separate deed and you allow that, and not for the situation where the parking space is another deed. So you were saying that you're sympathetic. I mean, for situations where there are two residential flats, I can understand that. But for a parking space, it is a very natural asset that is linked to any residential property. And it is unreasonable where this would be looked upon as two separate properties. That would be ridiculous for the parking space and the flat to be deemed as two different properties. So you have to solve that situation, and that is a situation mentioned by Mr. Wong, where there are two different deeds involved. And would that be treated differently? I mean, this is rather complicated. Concerning exchange of flats exemption, can you also consider this as well? Because the parking space is also relevant. And also, what about shop property ownership? Yes, perhaps people were not as sympathetic where the person is already a existing owner of a shop property, but it would also be relevant as a consideration as well. Yes, Madam Chair, members have raised different interesting scenarios, and in preparing the draft of the bill and having received certain inquiries, we also have considered different scenarios, and we will at the next meeting explain to you, especially where there are exchange of flats. We will come up with a table for your understanding, but it is really not a cookie-cutter situation. Going back to our policy intent, this is really targeted at multiple property owners, and there should be an additional stamp duty applicable to them. Now, where a person buys a property and the person is already at the same time owner of another property, there will be DST exacted. But this is not a situation where the person is owner of another property, not a residential property. Then there will not be any DST applicable. Yes, that's my understanding as well. Yes. Yes, we are talking about flat exchange and also residential or non-residential flats. I do not know whether it is this bill or the 2012 one. We have to be very clear about residential property definition as well, the usage, for instance, and residential blocks built in different times and eras in Hong Kong. So the definition of residential property itself has also to be clearly defined. Now, the question was raised just now as to half a property. What about partial owner of a property? What about those? Yes, there are such scenarios. Myself, for instance, I own half of the property. My better half owns the other half. What then? Absolutely. Yes, also on the 6-month time period, again, I would like to reiterate, as we have mentioned before, that for pre-sale, flat pre-sale, to have that attract the stamp duty is not correct. It would create major problems for the property market in Hong Kong. I would like to use this opportunity to reiterate again this point so that the government would reconsider. Otherwise, I might raise amendment proposals. Exactly. For the second reading for the 2012 ordinance, we also, in the reading, reiterate the considerations, technical as well as political. Perhaps the government has not completed their reconsideration. Perhaps when the time is right, they will come back to this meeting to tell us about their thoughts. Now, we are dealing with minors or mentally incapacitated persons exemption. As for the flat exchange stance, I think the government will come back to us on that, and this is not the occasion to discuss that, but you have just joined this meeting. I understand that you perhaps do not know that we are on 29AH right now. Mr. Wong Ting Kwang. Yes, going back to instruments involving minors or mentally incapacitated persons. For BSD and DST, there is an exemption for exchange of flats. No, only for the 2013 ordinance, rather. As for minors or mentally incapacitated persons, will they have a need to exchange flats? We cannot rule out that possibility, of course. And if that is the case, wouldn't they have to pay the DST first? And if it is a change of flats, then there will be a refund to them. Is that how it will work? Ms. Chen? Yes, the policy and the intent is that they will be treated the same as non-mentally incapacitated persons. That is, if they buy before they make the purchase before they sell, they will have to pay the DST first before there can be a refund. Yeah, so there is a 6-month time period. Is that right? Yes, exactly.
So let's continue. Permanent Secretary, next part. Mr. Abraham Sheikh. Well, just now she didn't answer Mr. Tony Tse's question of changing 6 months to a year or to 1.5 years. I don't think we need to argue back. The philosophy is that members are of the view that 6 months won't be practicable, particularly for sale of uncompleted flats. I think in the Bureau you all understand the facts. Well, if it is impracticable, then it's useless to provide that in the law. As Mr. Tony Tse said, why can't you accept our views first and then go back and consider whether you can change it to a year or 1.5 years? Otherwise, you cannot change anymore when it comes to the committee stage, because the administration is not going to accept members' CSAs unless the CSA is from a great councillor, a great member. Well, if I'm inclined to cast a dissenting vote, if you can be fair in handling this matter, I can consider my position again. I think the administration will consider members' views. They've not completed their deliberation yet, so they're not in a position to give you a final reply now. She'll consider your views and then report back to us the final results. I think property change is definitely one factor of consideration. This was raised right from day one of the scrutiny of the bill, in particular for uncompleted flats. 6 months may not be enough. As the chairman said, property change has all along been the concern of this Bills Committee. Mr. Tony Tse, Mr. Abraham Sheikh, Mr. James To, Mr. Wong Ting Kwang, and even the chairman have expressed their concern about this provision, particularly for uncompleted flats. From the signing of the sale and purchase agreement, if we only give 6 months, they deem that not enough and ask the administration to go back and reconsider. We'll go back and consider the views. We have to consider the policy intent as well as the effectiveness of the provisions and whether or not there's clarity. So we'll consider all factors concerned. As for this provision involving property change, 29DH is precisely about property change. As Mr. Tony Tse expressed his concern, The provision will involve transfer of properties among close family members and relatives. So we'll go back and examine those provisions relating to property change. And I'll, of course, report this back to our Bureau Director. I hope that the Bureau Director will consider property change. If I don't possess a residential property, I now own a shop. And for the first time, I want to buy a residential property. Will that be treated as a second property or the first? There are many scenarios, so you have to make sure that the law is clear enough and to make sure there are no loopholes. Well, as far as I understand, we're mainly on residential properties. Well, but this stamp duty also cover non-residential properties like commercial and industrial properties. If you exclude commercial and industrial properties, then the scenario may be simpler. All right, let's continue. 29. I'd like her to consider another aspect, see whether this is relevant. Now we're discussing change from a residential property to another residential property. But the deed may specify that the land site can be used for different land uses, but the occupation permit may just specify one use. Say if it is a composite site, the deed is for different uses, but the occupation permit may only specify commercial use. Deputy Secretary, to define whether a property is residential or non-residential, we have to look at its use. Basically, the IRD and in particular the Lands Department are very serious on this. They're very strict. They look at certain instruments. Number one is the land lease, specifying the land use. Secondly, they'll look at the occupation permit, which may also determine conditions and uses. If in any of these instruments there is a clear provision that in the past were stricter, that is, an instrument may specify that the land cannot be used for residential purposes, then that property will not be a residential property. Just now members mentioned car parking spaces. Then it depends. Number one, it depends on at the time of the purchase, the vendor is selling the car parking space together with the property itself. And then we need to look at the car parking space deed to see whether it can be segregated from the property. And then we can look at the instrument to be stamped to see whether there's evidence to prove that the property and the car parking space have different prices as specified. So the IRD will look into all these instruments. On all these issues, at the next meeting, we'll use another paper to explain clearly to members. Well, Deputy Secretary, I understand that you explain about the car parking space issue at the next meeting. Now, what if I am dealing with a composite building? The land lease is also for commercial and residential use, but then the occupation permit only specify one use, residential. And what if it is just for commercial? So what will happen then? When it comes to tax, we should have more clarity and certainty. Otherwise, you may come up with a lot of strange scenarios. So next time, would you please try to deal with different scenarios? Do you have any immediate response? If not, you can leave it to next time. It depends on the valid instruments involved, but the guiding principle will be clarified. The website of the IRD does carry some Q's and A's. So as far as possible, we'll try to handle all possible scenarios. But as land uses are involved, I don't want to adopt a too simplistic approach here. So I'll try to describe different scenarios to map out the guiding principle. Mr. Wong Ting Kwong? Just now I noted that the Deputy Secretary tried to explain the relationship between the property and the car parking space, and you try to find out whether or not they come under one single transaction. You mentioned whether or not the prices are separately set out. I suggest that you should not consider that aspect, because very often the residential property and the car parking space are set out under two different prices, and then they have their respective deeds and respective values. There is a very clear distinction between the two. Sometimes it's one deed, one transaction to handle both. But sometimes there are two different sale and purchase agreements and two different deeds. But in fact, the residential property and the car parking space are bought and sold in one single transaction. All right, I think members' views are heard very clearly. Let's proceed. Let's continue. Chairman, we now come to Clause 10 of the Blue Bill. In Clause 10, we propose to add Division 2, Conveyances on Sale, General Provisions. And there are also general provisions. Under the BSD and SSD provisions, we have similar provisions to mirror those here. The first one that we propose to be added is 29AI, except as provided in Sections 29AJ to 29AQ, a conveyance on sale is chargeable with stamp duty under Scale 1 of Head 1.1 in the first schedule. Scale 1 sets out the doubled stamp duty. And then for 29BA 13, it sets out the same provision, but we'll come to that later. When compared with 29AI, 29AJ all the way up to 29AQ specify the exemption arrangements and scenarios. Please continue. In 29AJ, certain scenarios are spelled out for Scale 2 rates. Scale 2 covers the ad valorem stamp duty. Our DOJ colleagues who are responsible drafting are of the view that these provisions will be able to spell out the details in clarity. So we have the first standard and the second standard. May I draw members' attention to bracket 2. This subsection applies to the conveyance if the transferee or each of the transferees under the conveyance is a Hong Kong permanent resident acting on his or her own behalf, and that transferee or each of those transferees is not a beneficial owner of any other residential property in Hong Kong, then Scale 2 ad valorem duty will be imposed. For bracket 3, it involves one or more than one person who is or are transferees, and one of them is a Hong Kong PR. and the remaining persons are not Hong Kong PRs, then they do not come under the previously mentioned bracket 2. If every transferee or all the transferees are closely related, say a Hong Kong PR plus a non-Hong Kong PR, and the non-Hong Kong PR is closely related to the Hong Kong PR, then if they're not beneficial owners of any other residential properties in Hong Kong, they enjoy Scale 1 ad valorem stamp duty to manifest the close relationship. Mr. James To, do I remember correctly? That is, under 29AJ, no stamp duty needs be paid. Now, if that close relative is not a Hong Kong PR, he should be subject to stamp duty, right? Right. BSD, right? Am I correct? BSD? Transferee, the purchaser. 2012 bill. Closely related. All right, you're using the exemption under the 2012 bill. Well, sometimes my thoughts are too complicated. Okay, then I'll leave this question for the moment. For 1A, the property concerned is residential property. Let me ask again. You said you would look at various factors. Do you mean they have to satisfy all the requirements or just one of them? You give us a paper. Yes, we'll give you a paper. Perhaps I'll defer to my colleague for some preliminary comments. Mr. Tam, I think Mr. To was referring to a property which you don't know whether it is residential or non-residential. Under the stamp duty ordinance, there is a definition for non-residential property. Under that provision, we'll look at certain instruments. If an instrument says that no portion of that premises should be used for non-residential purposes, then that is a residential property. So, even if a portion of the property is to be used for residential purpose, it is still a residential property. As for 29AJ, we've already decided that this is a residential property before the exemption is granted. All right, let me give you an extreme scenario. The deed or the land lease says that it is a commercial and residential property, but the occupation permit says it is a commercial property. I don't know whether there are such properties. I'm speaking as a taxpayer. If the land lease says that the property cannot be used for residential purpose, but then when the property is built, we don't know why, in the occupation permit, it does not say that it cannot be used for residential purposes. So, what is it then? Don't tell me there's no such case. We've seen all sorts of cases. Deputy Secretary, just now we mentioned different land leases and occupational permits, OPs. Well, the use may be specified as composite, that is, commercial and residential. We already said that we'll look at the specifics in the laws. I'll defer to Mr. Tam for some elaboration, but I hope that Mr. To can understand that we would like to offer an explanation in more detail in writing. But perhaps Mr. Tam can say something first. Mr. Tam, well, to put it in simple terms, we should look at the latest instrument as to the permitted use. What is the latest instrument?
As Mr. To described, perhaps there was an original land lease, and later on there was an OP issued allowing for commercial property usage. So you're saying you would follow the OP? Well, Mr. To, I urge the government to go back and think clearly about it. I do not think the answer just now had any legal basis to it. Well, basically, Ms. Chan had asked the colleague to talk about the actual implementation. But I think the response from the IRD was completely not legally unsound. That's what I think. Perhaps we can go through this in detail, and according to my understanding, I think we have to think about the law first, because this is an ordinance, and we will think about or consider implementation after. Can you please explain how you understand the legal basis of this, and also whether there should be amendments and what the reasons for amendments are? In the end of 1960s and early 1970s, there were a lot of flats for composite use, residential as well as commercial. And commercial flats then were less expensive, and they were bought or transferred as commercial properties. I'm sorry, I need to go to the lavatory. Yes, this is not on, the calculation is not on OP, but whether it is property for residential or for commercial use are clearly specified in the, and in my urban renewal work, I have come across many of these cases, and that is the land lease would specify the usage. As for OP, it is really a buildings authority issued document. The lease condition is actually enshrined in the land lease itself, following the usage of land in the area, etc. So there are a number of these flats or property with composite, that is commercial as well as residential use. So do be careful when you consider this. Thank you, Chair. 29A, in the definition there. As long as there is one document which says that the property is not for residential use, then it will be deemed as non-residential use property. It does not have to do with whether the document is an older one or a later one. Would you please go back and consider that, IRD and the government? Exactly. Concerning non-residential property, 29A definition, we'll be looking at that. And also on the 26th of March, we have issued a background paper for the LegCo. Under Note 1 there, we have also talked about the residential or commercial use of a property, how it is defined. We have also specified that. There are a number of documents we refer to, the lease agreement, the mutual deed of the building, and also the permit issued by the Buildings Authority, and also certain new urban planning legislation which may limit the land use detailed in the documents. So the documents will be looked at, and if part of the property cannot be used for residential purposes, then it will be deemed as a non-residential property. Madam Chair, I have a question. If at the time of purchase it was a residential property, but later on it was changed to a composite use, as Inland Revenue mentioned just now, which one is it then? The original lease condition was as such. You have to be very clear. You can use one of the many, But you cannot say that all these will have to be satisfied, all these conditions. So it is not a basket definition or condition. And even if I look at the document, there are different ways to interpret it. We have to be very clear. Yes, to report on the lecture brief and 29A, there is a definition for non-residential property. And when we discuss this particular stipulation, we are using 29A in the original stamp duty bill as a basis of discussion. All right. There are a number of questions raised by members. Would you please come back to us and clarify those in the next meeting? Mr. To? Madam Chair, I don't know whether this has been raised before on close relations. I'm sorry, I've forgotten the example I wanted to raise. Yes, I remember you raised this in the 2012 bill. Yes, I don't know whether I have raised it in the 2013 bill. There are certain situations, for example, where there are 3 persons involved. Then A and B may be close relations, but B and C and B are also close relations, but A and C are not. Now, that is problematic because if you say each of, quote unquote, and where A and C are not close relations, then that may be problematic. But would it be too far-fetched in the sense that totally unrelated persons would be involved in the party? Well, if your logic is sound, then certain persons, where they already have to pay PSD, and even if you say that they satisfy close relations criteria, then in fact we have to go the whole hog. I hope you understand what I'm talking about. Let me try. Well, this is the existing definition, but I think we can always revisit it. Yes, Ms. Chen. Madam Chair, concerning the definition of close relations and what it covers, and where there are more than one party concerned, what exactly is their relationship? Whether each of the multiple parties fall under close relations. I think actually for ASD, BSD, DSD, they are the same in facing this particular question in the definition of close relations. For SSD, BSD definition and coverage of close relations, we have made it also applicable for DSD for exemption purposes. We believe for SSD and BSD, for the exemption extended to close relations, where it does not affect the policy intent, and where it can cover most of the close relations in different scenarios, then we would continue with that usage. But there may be scenarios where the parties to the transaction may not be close relations. That is the A and C situation that you have mentioned. And therefore, in the DSD scenario, we would want to strike a balance. And therefore, for the coverage of close relations here, we would want to continue with that usage here. That is, for the exemption extended in SSD and BSD, we will follow suit. And we will not exceed that or subtract from that. Yes, the 2012 ordinance had been passed. Had the IRD received any cases or controversies concerning closely related parties? But Madam Chair, you can imagine, let's say there's a father with a son and a daughter-in-law. Well, that already flouts or does not fall within that definition. But this is really a core family, isn't it? So I find it quite unacceptable. If you say there are 6 persons and some of the parties are uncles twice or 3 times removed, then I can understand that the exemption should not be extended. But I think for a generation, being the purchaser and the next generation as also as one of the purchasers, let's say, as I have mentioned, my mother and my wife, aren't they closely related? You cannot say that they are not. I understand your worry about 20 purchasers, and at the end of the line, you do not know whether the last purchaser is really related to the first purchaser. I can understand that worry, but if you're talking about situations where they are genuine, not abuse, or if you worry that a person may want to marry another person just to save on certain percentage of tax stamp duty, that is unimaginable.
Some scenarios involve one or more close relatives, and sometimes the act may be confined. Will submit a paper. Well, in the past, there are these adopted sons. And in the Chinese race, adopted sons can be closely related to the persons. What if there's a legal instrument, but what if there is not? Anyway, an adopted son is treated as a genuine son if there's an instrument. Let's proceed to 29AL. For replacement properties. When we scrutinize the 2012 bill, the original proposal from the administration covers those people affected by the act of the URA in acquiring their property. And then these people have to buy a replacement property. We haven't studied AK yet. Well, she only explained AJ. As far as I remember, AK has not been explained. Yes. Well, I think we thought we went through that already. So let's go back to AK. Sorry, I omitted that. 29AK. Conveyances between closely related persons. In bracket 2, it is said that if the transferee or each of the transferees under the conveyance is closely related to the transferor or to each of the transferors under the conveyance, where there is more than one transferee under the conveyance, the transferees are also closely related, then exemption arrangements will be made. As for the definition of closely related, will follow the definition under the BSD and SSD regime. My understanding is that under such scenarios, they are exempted. Now, please think about this very carefully. If the mother and the eldest son possess a property, and the property is to be transferred to the younger brother and his wife, then it won't work. The mother and the younger daughter-in-law are not closely related, right? You have to think about this. Society may say, well, you can't even allow that. They're so closely related. So please go back and think about this. Well, your definition is rather stringent. Well, but the scenario I just mentioned easily happens. Well, we have to draw a line somewhere. Well, this definition is used under BSD. and all stamp duties, right? Yes. Well, we have to draw a line somewhere, so the coverage will be limited. If it is the mother plus the elder son transferring the property to the younger son, then among the three of them, they're closely related. The wife of the younger son is closely related to the younger son, but is not closely related to the mother-in-law and the brother-in-law, and then she's not exempted. But if the mother and the elder son transfers the property to the younger son, the exemption can be granted. If the younger son wants later to add his wife's name to the deed of the property so that she becomes a co-owner of the property, then there'll be another instrument involving adding and deletion of names. We'll have another provision to handle the adding and deletion of names. I'll elaborate then. If a man wants to add the name of his wife, and the wife does not possess other properties, then we'll consider that as a close relative, and she does not need to pay Scale 1 stamp duty or Scale 2 stamp duty. No. She has to pay Scale 2 but not Scale 1. So, she will have to pay half a portion of stamp duty more. Under the existing provisions for change of names and addition of names, no ad valorem duty needs to be paid, but it depends on whether the persons involved possess other properties. We'll go back and tabulate our analysis of all these scenarios. Well, I wait for your table. Now, the mother, you're saying that the mother and the elder son transfer the property to the younger son first, and then the younger son will transfer half of the property to his wife. That means extra stamp duty. Extra stamp duty. That's similar to paying BSD. So, the problem is not solved. It doesn't matter. Just go back and think about this. You see, society won't consider such scenarios as abuses. Well, in fact, the definition is defined right from the very beginning, and we'll have to follow that definition. And Mr. James Stowe has already put up his request. Well, let's continue. 29AL, the handling of replacement properties. Under the original 2012 bill, if some people are affected by the land acquisition or land resumption ordinance and the URA's acquisition as well as compulsory sales and have to purchase a replacement property, then they can pay Scale 2 standard rate with no BSD. And for the 2012 bill, during the committee stage, some members pointed out the MTR, land resumption, water disposal, and other scenarios. And then in the 2012 bill, we made an amendment to include those scenarios in bracket 2. So for the 2013 bill, our policy is to take care of these affected people who have to buy replacement properties and to offer them similar exemptions. So consequential amendments will be made. So for the time being, your thinking is that you will observe what's enacted under the 2012 bill. Right. Mr. Toh? For this concept of replacement property, let's not talk about the title to underground space. I'll argue that with you later. For a 400 square foot flat, if it is possessed by N persons, and each of these N persons respectively purchases another property, will they all be exempted? So, N shares of one integrated property. Will the government agree that such a scenario will occur and the government does not consider that a loophole and can allow it? Well, if I heard Mr. To correctly, a property is owned by N persons, and each of these N persons purchases a respective replacement property. So each of the replacement properties will be exempted. The answer is yes. So the government does not consider this a loophole. I consider this a very big loophole. Deputy Secretary, I noted that the same concern was raised during the scrutiny of the 2012 bill. The legislative intent is that we do understand that some persons may have to purchase replacement properties. So the exemption is offered from a more lenient point of view. That is, we would like to take care of the affected person's need to buy a replacement property. And each of the affected persons may have to buy a replacement property. That's why we offer the same exemption arrangements. We're of the view that this exemption regime should be observed. We won't, because of the policy intent of the BSD, add strict requirements on top of the original regime. Well, the composition of the bills committees are different. In terms of size and value, why can't you confine yourselves to a reasonable scope? During the resumption debate of the 2012 bill, I already asked N persons can buy coupon, so to speak, in advance. They buy a 400 square foot property, and then each of the N persons go to buy a replacement property. So the coupon, so to speak, is very cheap. This scenario may happen. So why don't you restrict the size and value of the replacement property? I think that's rather reasonable. Why don't you do it? Deputy Secretary, as for the size and value of the replacement property, if we are to specify in law a ceiling, there are practical difficulties. We don't think that's an ideal arrangement. In actual fact, property values fluctuate for the affected persons in relation to their property ownership needs. They may want to buy a bigger or smaller flat. A person may own the whole or part of a property originally, and eventually he has to identify a replacement property to satisfy his property ownership needs. So if we are to set rules and regulations for the property prices, there will be difficulties. Mr. Sheikh first. Madam Chairman, Mr. James To raised the same issue when we discussed the 2012 bill. If 10 persons buy a property of a value of $10 million, then each share will cost $1 million. But with the $1 million coupon, each of these 10 persons can buy properties to the tune of $200 million. So this is a rather difficult issue. Say some companies specialize in such businesses. Well, no problem for such businesses, but there is a big loophole. 1 becomes 10, 10 becomes 1,000. You have to look at the possible loophole and its impact. You may lose a great deal of tax revenue. It's not $1 million. The person may buy $300 million worth properties. Is this exemption applicable to companies as well, not just individuals? Companies? Possible or not? Some owners are companies. So long as there is this land acquisition. Well, exemption for the dual hash measures, and now we have exemption again. Of course, you have to estimate very accurately that they're going to resume your property or acquire your property. Well, Mr. Sheck cited some companies. Well, many 400 square foot companies are owned by such companies. They just sell such shell companies to you. A shell company is a coupon. Then you can buy 1 billion worth luxury properties. So that will benefit these companies. Of course, here I'm a member of the Bills Committee. I cannot buy the shares of those companies. Otherwise, I'll enjoy a great deal of benefits. How can the government let this off the hook? Well, some redevelopment projects may be discussed for over 2 years, and only a few flats remain unacquired. For speculators who want to evade tax, they can buy such shell companies. Mr. Sheck, you want to tighten the provision?
Yes, they can change to another flat which does not attract BST and DST. Yes, 15% BST and also avoid DST as well. So let's say we have an example in a renewal area. Let's say through a company, there is a purchase of a property. And even if the price is 5 million, I pay 10 million. And having bought this coupon, I buy a property worth $400 million. That's a scenario. Are there many such cases? I would like to know from the Secretary. Well, you have a solution which would solve all problems, but you don't seem to want to adopt that. My question to the government is whether there are many such cases. And they are of the opinion that we should not slap on more stringent restrictions. Well, not on the IRD records, not too many such cases, but we will go back and look at it in any case. Yes, we have people from the property industry. No, I approach it as a legislator. I have the responsibility to point out any loophole I see. And that is why the chairperson raised the issue about Hong Kong people buying Hong Kong property. I mean, for any law, it has to be equitable, it has to be fair. But this is a major loophole to my mind. There has to be a level playing field even for the property sector. But there may be situations, not the property developers, but other people who are utilizing this as a loophole to benefit or profit. Yes, Madam Chair, I think we have to be careful in considering this. And also for companies which effect the purchase, and at the same time, if there is no cap to the value of the property, how should we handle that? And at present, for some of the citizens, they are exempted from DST. They only need to pay the BST. We will also have to see how this would affect the small citizens in Hong Kong. How can we avoid making them pay double stamp duty? That D is bigger than this D. This is 4.25D. That is 15D. 15 plus 5 is 20. 20% is a lot. 29 a.m. We continue. Other conveyances on sale chargeable and ad valorem tax stamp duty at scale 2 rates. This is a conveyancing made pursuant to a decree or order of any court, and they are only chargeable with scale 2 rates. In the first SSD, there were many such enforced items. Well, basically, will there be a laying out of where it will not be applicable? The first SSD was about short-term speculative transactions, and there were some 4, 5, or 6 items under that. And here I see only 3. From the phase 1 of SSD, we have brought down a few items under this particular one. For example, orders or decrees from the court, or certain mortgagee. All these we have basically copied the SSD exemptions. But there are less here than the SSD. Will the CSA change that? Yes, we're going through the CSA. But in fact, we have to be fair. They have already responded to members' questions, and they have prepared a paper as well. Can you perhaps at this juncture explain to us the CSA arrangement so that we will know how you're going to approach this? Is there a table that you will lay out? 943. Well, Madam Chair, because of time, we finished this paper end of last week. We have included all the amendments, including exemptions, brought down from the 2012 bill. And that's why at the beginning of the meeting, I suggested that in the markup version, we work together with the Lecture legal advisor. We will put any other amendments into this copy as well. That will make it more convenient for you, because even over the weekend we were working on this. All right. If there are any CSA relevant during our discussion, would you please raise them so as to be more streamlined in our discussion? Madam Chair, we have to have everything ready. All the items under this particular stipulation, and you can prepare a very big document in the sense that it is the paper needs to be very big in size so that it will be clear for our referral. Otherwise, it will be very confusing. That's the format I prefer. Thank you. As we do go clause by clause, and before we have a marked up copy, I would like to perhaps suggest that we have a table marking out all the amendments. But Mr. James To need not worry, because we will be going through these amendments one by one. Madam Chair, perhaps we should not go clause by clause, but rather look at those which have not been amended. I think that will be a lot more efficient. We need a table. Of course we need a table, but we don't have the table now, do we? Legal advisor? Yes, I understand. But there are certain stipulations which are interconnected. Ms. Chan, I understand where Mr. Sheck is coming from. Where it comes to policy and like a minor issue just now, as much as possible, I will raise these as well. You have to trust the administration here, because this is very clear. This particular document I'm holding on to. And also in 943, for technical as well as repetitive issues, we have already listed them out. And when we have the final version, I think that will be a lot more convenient for you to raise your questions. Otherwise, this clause by clause, this will be more beneficial to the clause by clause procedure. Well, after all, it's only just the few of us, and we've come to time yet already, end of the meeting. Yes, so perhaps you all think that this is the right time to stop. Anything else? Nothing else from the legal advisor? There are a number of issues. The government has a lot to do. Yes, let's end the meeting 5 minutes early. (29A and AO). You're more familiar than I am. That is for property, that the equality money for residential versus non-residential property. And that is on the receiving end, whether the party has other properties or owns other properties. And in this case, there will be the scale 2 of equality money would be applicable. As for 29AP and AO, it would be the addition of names of those closely related. I do not know whether you know about the details, but I think in the next meeting, I will put in this issue as well. That is for clause 10. And also for clause 11 is about the mirror provisions. So that will save us time. By so doing, we can go into exchange of flats very quickly in the next meeting. Can you work together with our legal advisor on the table so that it will be clearer for members to discuss the clause by clause? Can you do that? Will you try your best? I know this is a very high demand. I know that the secretary is working very, very hard already. All right, let's stop here. And I remind members, date of next meeting, March end, 24th. I hope you will go back and consider the 2012 bill and some of the questions raised by members and some of the issues raised by members at today's meeting. And then we will continue with the discussion of the issues in the next meeting, issues that our members are concerned about. Thank you.